Welcome to the Celebrity Estates Wills of the Rich and Famous podcast. In this podcast, we break down high-profile celebrity estate planning cases for advisors and their clients. Most celebrity estate catastrophes are based on the same issues that everyday people face, just with the volume turned up. Our goal is to identify and extract the individual estate planning issues that lie at the heart of each story. We then discuss what advisors should expect and how to avoid common pitfalls. Hosted by WealthManagement.com Senior Editor David Lenok.
Hello, everyone, and welcome to the latest episode of WealthManagement.com's Celebrity Estates, Wills of the Rich and Famous. For anyone new to the podcast, in each installment, myself and a guest take on a different celebrity estate and attempt to extract some key lessons that planners can apply to more traditional clients. The idea being that celebrity estate planning stories, although often ridiculous in their details, generally have at their cores very basic issues that could just as easily apply to non-famous or fabulously wealthy clients. To learn more about estate planning and how you can better serve your clients, visit wealthmanagement.com/trusts-estates. Our monthly journal features tax law updates, wealth planning, retirement planning, and much more, written by thought leaders in the industry. That's wealthmanagement.com/trusts-estates. We're joined today by Sean Weissbart, partner and co-chair of the Tax, Benefits, and Private Client Practice Group at Blank Rome. Clients turn to Sean to handle all aspects of estate planning, the administration of trusts and estates, and the representation of beneficiaries and fiduciaries in contested matters in surrogate's court. Sean's extensive experience includes advising international families on the impact of U.S. tax laws on their wealth. In addition to his law practice, Sean serves as an adjunct professor of law at New York University School of Law, where he teaches income taxation of trusts and estates, international estate planning, and tax aspects of charitable giving. Thanks so much for joining us, Sean.
David, it's great to be with you.
So the subject of our episode today is a tragic and sadly recent one, Rob Reiner. Normally, we wouldn't tackle a topic this quickly, but there are unique aspects of the Reiner story that offer the opportunity to tackle some issues that may not really come up again anytime soon. So, we realize this one it may feel a bit icky and ghoulish, but we're going to sort of power through just for the science. Reiner was a beloved American actor, director, producer, and activist. He acted in the All in the Family television series and directed and appeared in numerous movies, including This is Spinal Tap, The Princess Bride, When Harry Met Sally, and The Bucket List. Rob Reiner and his wife, Michelle Singer Reiner, were found dead in their Brentwood home with their throats slit on December 14th, 2025. The primary suspect in the murders is the couple's 32-year-old son, Nick Reiner. Nick, who's been open in the past about his struggles with addiction and homelessness, allegedly committed the act after a heated argument with his parents, according to what few sources have come forward at this point. He was arrested shortly thereafter and is still awaiting trial at the time of recording. Rob, 78, and Michelle, 70, left behind 3 children, the aforementioned middle son, Nick, as well as eldest son, Jake, and youngest daughter, Romy, who was sadly the one who discovered her parents' bodies. Though movies and media would perhaps lead one to believe that this sort of thing happens all the time, murder is not a particularly common issue for estate planners to encounter, let alone a murder where the killer is a likely beneficiary of the estate. It's not a lot of knives out scenarios here. That said, there are, of course, laws that deal with this unlikely scenario, so let's start with those. Sean, what are Slayer statutes and how and when do they apply?
Slayer statutes prevent someone who committed a murder from financially benefiting from their victim's death. And so they apply when someone has killed someone and is also a beneficiary of the estate or of a trust of the person they had murdered.
Interesting. In this case, we're dealing with maybe the most famous Slayer statute. This is California Probate Code, Section 250. This is the Menendez brothers Slayer statute. I think that's what brought the idea of a Slayer statute into the public eye, maybe most recently. And as Sean mentioned, it prevents a person who feloniously and intentionally kills another from inheriting property and benefiting from wills, etc. It treats the killer as if they predeceased the victim. Sean, do you mind expanding on sort of what that means in the terms of an estate to predecease?
Sure. So an estate would benefit a person, but people prepare their estate planning documents in many cases decades before they may pass away. And so the person that they may name as the beneficiary, there's a possibility that that person may not be around at the time the decedent, the person whose will or trust we're administering, actually dies. And so in that situation, sometimes there would be alternate beneficiaries who would take from the share of the person who is deemed to be predeceased. So if you predecease someone, the alternate beneficiaries would inherit, or it would be the share you're getting would go to other people. And so if you're deemed to predecease someone, your interest in this estate is going to go to other people.
Interesting. And so how, obviously each state has their own version of this, so we're sort of generalizing here a little bit. But does that apply to just the killer themselves? Does it affect their line, their issue, if you will?
There's not guilt by association. It just affects the killer themselves. It wouldn't affect the killer's descendants, at least in California. But Nick had no descendants. So in his situation, I mean, I haven't seen the Reiner's estate planning documents, but his interest, I would assume, would likely go to his siblings.
Yeah, I mean, we're just this is not a fact. I know I say at the top of the show that celebrity estates are just like regular estates, except for the fine turned up. This is not one of those. We're sort of just kind of doing a law school final exam question here with this one. It's sort of more of an academic exercise, just because there's so few opportunities to talk about these things. So yeah, and Nick doesn't have issue, but sort of in the hypothetical situation that the mystery killer does, it is possible, I guess, technically, depending on the structure of the will and the estate, that the killer's children could benefit, I guess. I mean, be still maybe beneficiaries of the crime.
Yes.
We talk about the Slayer statutes. How is it invoked? I mean, what are the prerequisites for actually, like, is a criminal conviction required? Like, Nick has been arrested. Is that enough? Or
being arrested is not enough, but a criminal conviction is also not required. And David, you mentioned these two terms, feloniously and intentionally killing someone. So what has to be proven for the Slayer statute to be triggered is that Nick Reiner feloniously and intentionally killed his parents. That does not say a criminal conviction has to be acquired, right? If he is criminally convicted, and we should talk about insanity, but barring the insanity issue, if he's criminally convicted, he will be excluded from inheriting. But if he's not criminally convicted of first-degree murder, like an intentional murder, he might still be impacted by the Slayer statute if it is proven that he intentionally committed this murder. And if I may, what's different about the criminal world, right, from the Slayer statute, is many people, we're familiar in criminal court, a crime must be proven beyond a reasonable doubt. So even if it's more likely than not that you committed a crime, but there's some reasonable doubt, right? I'm 80% sure you did this. That doesn't mean that you're going to be convicted of murder, because there's a 20% chance that maybe you didn't do it. That would be reasonable doubt. In California, the Slayer statute is triggered if it's proven that you intentionally committed this crime by what's called a preponderance of the evidence. And that really means that it's just more likely than not that Nick Reiner committed this murder. There could be reasonable doubt, but it's more likely than not. And so in that way, the Slayer statute is very distinct from what would be required for a criminal conviction.
Yeah, sort of a 99% sure versus a 51% sure kind of situation here.
Yes.
Effectively the difference between criminal and civil court, right?
Correct. And there are some Slayer statutes in other states where it's an in-between the reasonable doubt and preponderance of the evidence. Some of them are what's called this middle ground. It has to be shown by clear and convincing evidence, but that's not California. It's preponderance of the evidence.
And I realize to our non-lawyer listeners, it's going to sound like Sean just said the same thing 3 times, effectively, like clear and convincing, preponderance, beyond, like, to layman, that kind of just sounds like, oh, this is such a lawyerly thing where these guys are just using 3 different terms to describe the same thing. These are very different standards. Yeah. It's materially extremely different, I assure our listeners.
And I love how you said it, David. Think about it. 51% is preponderance. let's call it clear and convincing 75, and beyond reasonable doubt is 99. I think colloquially that's a good way to look at it.
Yeah, these are established terms is kind of what I'm getting at in the legal field. The lawyers know exactly what these mean. The states aren't just making up synonyms for a lot of evidence. You mentioned insanity, so I think this is probably a good place to talk about some of the exceptions. Just being the killer, there are a few exceptions that can let you off of this. One is self-defense, usually an exception to most things. Insanity is another. Do you mind expanding on some of that?
For sure. So when we think of a criminal conviction, and this is a legal term, but I think it's commonly used, mens rea, right? Mens rea means mental state, right? What was the state of mind of the person who committed this murder, right? And remember, the Slayer statute requires that your state of mind be one that was feloniously and intentionally, right, committing this murder. And so if someone is doing that in self-defense, right, they haven't feloniously and intentionally committed a murder. And if someone is found not guilty by reason of insanity, their mens rea, their mental state, probably is not that feloniously and intentional standard that would be required for the criminal conviction or for the Slayer statute to apply. And so if Nick is I would say his best shot of potentially inheriting is if he is found not guilty by reason of insanity, because I think he would have a strong argument that he didn't intentionally and feloniously commit this murder.
Yeah, absolutely, especially given his history, his sort of a pretty well-documented history of mental health issues and drug abuse, which in itself isn't an excuse, but can sort of speak to further mental health problems. If he were, just expanding this out a little further into our fun law school final exam question hypothetical here, if he were to, succeed in such a potential defense, do you think it's likely that he would inherit directly, or would it more likely be under some sort of trusteeship or some sort of, since he'd been sort of, would that be held against him, I guess, in terms of whether he was, would be directly allowed to inherit the money, or would it,
So I'm going to give you a two-part answer to that question. The first part is going to depend on what the estate planning documents themselves say.
Yeah.
And for wealthy people like Rob and Michelle Reiner, it would be pretty unusual if any of the children's inheritance would go to them outright. It's probably directed to a trust that's managed by a professional or third-party trustee who has the discretion on whether to make distributions to any of the beneficiaries. And so regardless of Nick potentially being found not guilty by reason of insanity, the estate planning documents themselves may have those safeguards of his share of the inheritance going to a trust. Now, let's say that's not the case and Nick's share would go to him outright, or under the terms of the trust, there are to be outright distributions potentially at certain stages of life or upon certain milestones. If he's found not guilty by reason of insanity, we would then dig a little bit deeper into whether or not Nick is really eligible to manage money. And if someone is truly not able, for whatever the reason is, to manage their own property, there are conservators or guardians that may be appointed to do that. But someone might be found not guilty by reason of insanity, but that doesn't necessarily mean that they would be ineligible to be able to manage their own finances. But the odds are that if he is able to inherit, or even the inheritance of the other children is probably going into some form of trust.
So, and there are, of course, sort of very, murky areas. More recent things like assisted suicide are, I think, sort of not exactly covered in a lot of these statutes. I think that's sort of a weird gray area. But one of the issues that sort of comes up alongside this one, almost actually came up in the recent equally tragic Gene Hackman situation a couple of months ago, is that of simultaneous death. Normally, you have a married couple, you're going to, again, we haven't seen the Reiner's estate planning documents, but likely the first beneficiary of, certainly under intestacy and also, likely under the actual documents is the spouse. So what happens when, both spouses die at the same time? And I guess, what does the same time kind of mean? Like here, obviously they died it was exactly at the same time, but.
So if you can't figure out who died before someone else, the estate planning documents themselves may have a provision that says, I'm deemed to die first, you're deemed to die first, etc. And if that isn't the case, the law says if two people, you can't figure out who died first, that they're both treated as predeceasing the other. And so they're assets would flow through their estates based on assuming that they died unmarried in this situation, that they both would be treated as having died unmarried, unless the estate planning documents themselves have an ordering provision.
Mm-hmm. And that could, I mean, obviously, if you're pulling out, just magically lifting the main beneficiary out of an estate plan, depending on how thoroughly and well structured the plan is, that could potentially mess things up pretty badly.
And actually, one thing that I think is particularly interesting for the death order here is that Rob Reiner had 3 children other than Nick. Michelle Reiner just has 2 children other than Nick, because Rob, I believe, legally adopted the child of his first wife during their marriage. And so he has 3 children other than Nick, while Michelle has 2. So depending on what their estate planning documents do or don't say, the ordering provision could result in the flow of assets going more to Rob's child, who's not Michelle's, may be impacted.
It's very interesting. It's sort of, this is why I call this a law school exam, because it's all sort of like trying to follow.
That would be on my exam if I was drafting it.
These potential schemes. I know in the case of, I had to look this up because I was writing about the Hackman case a couple months ago, but I think California, it's up to 5 days, right? That is, I think 5 days is the standard for what's considered simultaneous. So simultaneous doesn't necessarily have to be at the exact, it doesn't have to be like, boom, car crash, gone.
Correct. Every state has a period. I believe California is 5 days. I know that's the case in New York. So if it's not proven that you survived by at least that time period, you would be deemed to have died simultaneously, and you're both predeceasing the other.
Oh. Well, let's see, California, a community property state. Does that have any impact here in terms of you're dealing with a simultaneous death? Does the fact that it's community property make it more or less complicated?
So when you have community property, it's treated, the property that's deemed to be community is property that each spouse is deemed to own together. But if there's a simultaneous death, then each spouse's share is just going to go as if they each predeceased each other and would go in accord to the beneficiaries of their estate plan. I think it's unlikely to matter, other than in the situation I flagged about Rob's child from his first marriage.
So, when I was looking at this, one of the interesting questions, someone like, Nick Reiner, and we don't know much about his finances, but obviously like his legal defense fees are going to have to come from somewhere. Could that possibly be drawn from the estate itself at this point, before we know that he's, before we've sort of proven by the correct standard that he was the killer?
I've thought about this, and I think it's most likely that Nick is paying from his legal fees in one of 2 places. Whatever Nick had in his own pocket, right? Not in a trust, but in his own pocket, which may be substantial given the wealth of his parents. That's still his money, and the Slayer statute wouldn't impact that. So he may have his own wealth, even if he had received it by gift from his parents, that he could use to cover his legal fees. I don't think that in terms of the assets in the estate, that he's receiving distributions yet as if he's a beneficiary. But I wonder if his siblings are, what a morally difficult situation they're in, right? I don't know what they believe or not, of course, but here their brother who clearly was suffering from substance abuse, is alleged to have committed this horrible, horrible act. Their parents are now gone, but it's still their brother. I wonder if they may be digging into the whole pot of the inheritance and saying, hey, Nick, like, let's pay for your defense, giving him a shot to maybe prove that he was not in the right mental state at the time and should be perhaps acquitted by reason of insanity. So my guess is he's either using assets in his own pocket, or his siblings, who may have some authority over the funds, are helping him out. And, if ultimately the Slayer statute is triggered, if his siblings have helped him out, that could have gift tax consequences for them.
So, we're coming towards the end of our time here. I mentioned right at the top that this is sort of atypical for this show, and that not the most relatable fact pattern here for the average person. But do you see anything in here, any sort of lesson for sort of a more traditional estate that can be pulled from what's going on here, or sort of to highlight the importance of?
As you mentioned, David, this is not a fact pattern that I think touches most people. Obviously, every family has their share of problems and their stories and the circumstances that make them unique. But it's extremely, extremely, extremely unusual that a family member is accused of murdering another family member. That's not something that people plan for in the context of my office, and or really, I think anywhere. But that being said, I think that there is a lesson that should reach everyone. Estate planning is very important because you want to make sure that your assets, whenever you're gone, are going to go to the people you care about in a method that protects them from taxes, from creditors, etc. And Rob and Michelle Reiner went at a time that was unexpected, right? Other people know when they're going to go, right? But other people, it may not be, it's very rare that you're potentially murdered by your child, but there could be a horrible accident. You could die unexpectedly from illness or disease. And so there are people, right, whose time comes when they don't expect it. And then there are people whose time comes when they are expecting it. They're suffering from a long-term illness. They've gotten much older and they know that their days ahead of them may be far, far less than the days behind them. And so it's important not to procrastinate in doing estate planning, realizing that although Rob and Michelle Reiner went unexpectedly in a very, very unique and rare circumstance, it's possible that anyone could go unexpectedly, even in a more traditional circumstance. And so don't delay thinking about what should happen to your wealth when you die.
Mm-hmm.
And that's true no matter how little or how much you have.
Excellent. Well, I'd like to thank Sean Weissbart for coming on and talking about an unusual and a little bit difficult topic, but an extremely interesting one nonetheless. Thanks so much, Sean.
David, it was a pleasure being with you. Thank you for having me.
And for all listeners, I'll see you, or I guess you'll hear me, on the next episode of Celebrity Estates, Wills of the Rich and Famous.
Thank you for listening to the Celebrity Estates Wills of the Rich and Famous podcast. Click the subscribe button below to become notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of WealthManagement.com. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning.